Abusia, we Jack Bawe MP, or Sanso lawyer Jerry Ahmed. We onya lawyer, onya MP, or a journalist, Citi TV, Citi News, journalist. And we didn't do myself training. Abronya issue we Yama Abronya bill. And ya remandeno into den na wasan kamoye as lawyers for more party no munim the right path. I'm filing new application. Edeko High Court with appellate jurisdiction. Now Oma review situation no over 10 decisions. So na be abronya benya bill no mo anya na sa. Ena hey ne na ya. Ena ya ntia na dede hunu. Ena mo filing new application I join say China and on Bashano. When the Chamusa Quano. Nana Jerry Ahmed. Any Citi News journalist with Umar Sanda. With the same issue, no. Shanungwasha Jerry Ahmed Etina as a lawyer. Emma journalist no. Egunu. Tie, udeti. Shanungwasho. Na Emi de say a Citi News and a copy. Minim say a copy from Bidia. Enenka. Yanime to the Becabani Sumusa. Nezo sa journalist we Emma Jerry Ahmed wuni say so onimrana on fam rani nya djuma manan kone na banchire bia ti journalist no tie odeti.
No, and people are not talking about them. And when people are sent to particular courts when they have a situation we can't see. How do you say that you are remanding somebody just because if you let the person go, if you should grant the person bail, the person will be talking again? Are you kidding me? Are we serious?
Is that not provided in Section 96 of Act 30? What did the judge at the Circuit Court tonight do really, which is against the law? If he went under that section,
which is what? That you should keep somebody behind bars in a misdemeanor or offense. That you are not allowing the person to make any comments, to even apply for a bill, and when an order is even requested, we couldn't even get the order. Is that what you are saying? Is that the kind of criminal law we are being taught?
No, I'm just saying that the judge referenced.
Don't just say. Let's educate people.
No, but I'm looking at the official court record as published by your leader, the minority leader, and it says that the judge referenced Section 96 of Act 30, and that is to determine the grant of bail. And it is what he referenced in going ahead to refuse the bill. And I'm saying that you are a lawyer.
But that is even the point. But 96 talks about, first of all, is the person who is
for benefit of my listeners, summary.
Exactly.
It says that Section 96.5, the court is mandated to refuse bail if there are substantial grounds to believe that the accused, 1, will fail to appear for trial, 2, will interfere with witnesses or evidence, 3, will commit another offense while on bail, and 4, possess a danger or threat to the safety of the public or any individual. And I believe the judge came under the third one, which says that he will commit another offense while on bail. And this is because the police prosecutors said to the judge that this gentleman committed this particular crime while he was on bail from the police CID for engaging in another crime. And so we suspect that if you let him go, he would go and commit another crime. So please hold him. And that is why the judge goes into the two sides.
So Omaro, even if we should deal with 96, right, and assume that the judge had it right. First of all, my question is that this judge that is referring to 96, did the judge say that now Abonye, when it comes out, is supposed to shut his mouth? He wasn't supposed to talk. Or a commentary today said that, oh, judge way, or say. Does that amount to committing the crime you are talking about? And even if that is the case, this is my point. Even if that is the case, assuming without admitting that is the case, now you are telling the person that you are going to jail until the final determination of the matter. Omaro, have you heard that before? So it wasn't, you are refused bail. You come back maybe in 2 weeks or in a week.
But the judge didn't say until he's refused bail, and I've seen that commentary being made.
And what did the judge said? What did the order say?
I'm going to read the final. In fact, let me just read the direct order of the judge. Let me just read that. It says that by court, which is what the judges used to say what they want to say. He says the counsel for the accused prayed for bail on the grounds that the accused was already granted bail by the police. Counsel further submitted that the accused will be available before the court to answer to the charge leveled against him. The prosecution in his submission opposed the bail on grounds that the accused will commit further offenses when granted bail. Prosecution relied on Section 96.5 C.D. of Act 30 of 1960, Section 208.1 of Act 29 of 1960, and Section 2964 of Act 30 of 1960 to buttress his arguments. This court has considered the arguments put up by both counsel for the accused and the prosecution. The court is of the view that when granted bail, the accused will commit further offenses. The court specifically relies on Section 96.5 C and D of Act 30 of 1960. Accordingly, the bail application by counsel for the accused is refused. The accused is hereby remanded into BNI custody to reappear before the court at the next agenda date. And in your practice as a lawyer over the decades, I'm sure you have in so many, and Honorable Jerry Ahmed, you have so many times appeared before judges asking for your clients to be granted bail, which application is refused. You either wait and return to court the following time to make another application or appeal at the appellate court. What is wrong with this particular judgment?
Omar, do you have the next agenda? Do you have the next agenda?
Yes. In fact, it says that the prosecution is also ordered to conclude their work and file disclosures within 14 days to ensure speedy trial of this matter. The case is adjourned to 27th May 2026. That is what the judge said.
Very well.
And this is signed by His Honor Joseph Yenuban Kunsong, Circuit Court Judge, Accra.
This is proper journalism. Lawyer no say MPP Lawyers say ye educate public no. Since journalist no nya lawyer mo no, na educate lawyer no. Eh rade nyame. Enti dede na ekoso na ne de o client no, ye say wa commit crime, ama ni bail. And also commit sa crime we. No na police for no edema judge so there bi. And ye sama ni bail a o sabe commit biom ensa de ye remand no 2 weeks. Enti dey na as a lawyer oye. You file another application to court. Now Omar review say over 10 decisions no enyamwa. And way you say we and man penny way. Oh my team. Law now, Emra now. And omujina so. Edi refusal abronye bail. Any this is proper journalism. Umar Sanda nyamishira. Ekopia ya no for bi anima. She said mudi emotions. Ade o said emra no. Mudi emotions na ye. And ade o said emotions aye no. Mudi mra. Rade nyame. Hwe. And I want and the president mama and any o mo ye di mo chi a as a lawyer, journalist and educate you. The right path for us amofaso. O client you refuse to say be money bail because you see a nigga money bail and was akwa dey work commit crime bill. Into you see money bail bill ma or say into remand 2 weeks. O just say into this year when e go go masum say mo san go file new application and mo dey go court a ya adjoin say echina and e betina sa application so na ya hwe na review. Yes, 27th and obeba no 27th no so SI holiday. So mo hwe na ka mo dem rade ya djuma na mo ja emotions no. Ya as a lawyer some more part we pa kojo ponkroma ho. Why be lawyer why yes na abuse you. Jerry Ahmed your lawyer. Justice go your own lawyer. After you na minority leader na mo su SI lawyer. And so mo tuna nyu sa de we ya de. And I'm a toner, de. Na mo client in that so shame. ade o se ka modem bra e be simple no mo anya ne sa e na journalist mom na educate mu ye dam ase